Thank you so much for that very kind introduction, Svein. I really appreciate it. So I am just going to now quickly share my screen and hopefully be able to bring my PowerPoint up there. Okay, so do you all see that? Good, so nobody's objecting at least, so I assume you see that. So I'm very happy to have this possibility to give a presentation at this Futuring Nordics conference. What I will do in the 15 minutes that I have been allocated is basically to give snapshots of completed research and ongoing research, which I hope will be a good basis for further discussion. So usually when I speak about business law and sustainability, which is what I usually speak about, I start by saying what we mean with sustainability. In this context, after the wonderful keynote presentations this morning, I am just going to skip right to the summarizing point, which is that we see sustainability as securing social foundations for humanity now and for the future, while staying within planetary boundaries. So that is the grand challenge of our time, and that summarizes the grand challenges of our time, and that is the basis that we take in our research, and as we also did in the SMART project that Svein mentioned in his introduction. Before the SMART project, the major project that we had then was the Sustainable Companies Project, funded by the Research Council of Norway, which ran from 2010 to 2013. In that project, we had the possibility of undertaking a multi-jurisdictional comparative analysis of company law and also accounting law, but I'm going to focus on the company law part here, to try to find out if company law itself, as it is shaped today, is a barrier to integrating in that project environmental concerns better into the decision making in companies. And we found out that it's not company law that's the problem. Company law gives quite a lot of scope to business to integrate environmental concerns better, or in a more current setting to become more sustainable, to be a part of the transition to a sustainable future. But the problem is that company law doesn't say anything, or very seldom says anything explicit about what the purpose of the company is, why we allow companies to dominate as the legal form in our various societies, nor does it say explicitly how the board is intended to complete its role of promoting the interests of the company. So this has left a lot of space, and the social norm of shareholder primacy has taken over that space. So we use shareholder primacy as a short form for a complex mix of market signals and economic incentives, but the essence of it is that it dictates that shareholders own companies, that companies are vehicles for profit maximization for the shareholders, and that the duty of the board, and by extension management, is to maximize returns for investors. This is a social norm, and we distinguish this from the legal norm of shareholder value, which is at the one end of the spectrum, as we saw in our multi-jurisdictional analysis of what company law actually intends to say. And that is namely that when promoting the interests of the company, which is the board's duty, that in some jurisdictions they should put shareholders first. But no jurisdiction says maximize returns to shareholders. No jurisdiction says maximize returns for shareholders to the detriment of all other interests. So these are legal myths in that sense. This idea that shareholders own companies and that companies are there only to maximize their returns. But the social norm is so dominant that it influences business across the spectrum, from the shareholder value jurisdictions to the more pluralistic ones. So we concluded that this is a main barrier to sustainable companies. These results were confirmed in the more recent publication, which became a project in its own right, the work with the Cambridge Handbook of Corporate Law, Corporate Governance and Sustainability, which I edited together with Professor Christopher Brunner, where we managed to bring in contributions from practically all parts of the world in this 50-chapter major volume, including a Nordic chapter, which is especially relevant in our context, of course, written by Professor Jukka Mehonen together with Dr. Gudrun Jonsson. And this state-of-the-art volume shows that while there is an increasing interest in sustainability, and there are some initiatives here and there in various forms to try to bring sustainability into business, summarized very simply, and then leaving out the nuances, of course, is that the shareholder primacy drive is still a major barrier. And that also resonates with the findings of the SMART project, which more broadly looked at the regulatory framework for market actors to look at what is it that prevents and what promotes market actors, by which we mean businesses of all types and financial actors in the public sector in its many roles as market actors and consumers. What is it that prevents or promotes their contribution to a sustainable future? And we found so many promising initiatives. There is so much hope in the state of the art now, but unfortunately, the obstacles are still more dominant. So in spite of the Sustainable Finance Initiative of the EU and the so-called non-financial reporting directive, various steps towards more sustainable corporate governance, steps towards a more circular economy, we are still very much on a very certain path towards a very uncertain future. And when I say we in this context, I mean global society. So we found out that in the SMART project that to have a good possibility of achieving a sustainable future, we need to put into place some reforms. So we as an academic group put forward some academic reform proposals to the EU mainly, although these can also be taken up by other policymakers, including in the Nordic countries. And the obstacles that we found, they resonate also with the discussion that we heard earlier today, with the silo thinking, with the emphasis on economic growth, and again, the shareholder primacy influenced profit maximizing drive in business. So if we go then to Nordic business law and look at what Nordic business law says today, does Nordic business law today encompass sustainability or make it possible for Nordic businesses to shift towards sustainability? And again, this is just a small snapshot of the complexity of Nordic businesses in all the Nordic countries. First of all, we see the same scope and tension in Nordic company law. Nordic company law, which also, and again, is a micro version of the broader multi-jurisdictional analysis that we undertook. We see that Nordic company laws range from having a pluralistic approach to shareholder value, which in the UK version of this have in the enlightened version, which asks boards to consider other interests also when they're promoting the interests of the shareholders. Nordic company laws generally very hierarchical systems with often strong shareholders, and we will hear more about the significance of the public and private actors in this realm in Jukka's presentation later today. We see that the Nordic corporate governance codes, which directly address listed companies but which have knock-on effects on the rest of the business world, vary from strong shareholder primacy support, inadvertently probably, but it's there, to more emphasis on sustainable value creation. We do not, of course, only have companies, as in limited liability companies in Nordics. We also have, for example, cooperatives, which have been highlighted as a sustainable alternative. But research there shows that cooperative law is member-oriented, and there are abstract sustainability principles there, but there's no foundation for saying that cooperatives, per definition, are a sustainable form. And then we mustn't forget, of course, the SMEs, all of the sole entrepreneurs and micro companies that we have. This is all a part of the Nordic system of businesses, and in none of these regulatory frameworks can we say that sustainability is properly integrated. but there is room for it. But the profit maximizing drive pushes out a lot of the potential for this room to be used. So therefore, it's important also in the context of Nordic business law that we look at the potential for reform. And I draw here on the smart reform proposals that we put forward, which can be summarized under the headings of business, finance, and circular economy. And I will concentrate on the business part, where we put forward a concrete proposal for changing EU company law, which would then mean changing the business law of all the countries of the European Economic Area. So the EU plus Norway, Iceland, and Liechtenstein. It's in a Nordic, no, sorry, our proposal is for a change in the EU company law directive, but we speak generally about undertakings in the EU terminology, which is then much broader than companies. So it fits with the Nordic business law approach. First of all, we suggest that company law, business law should take back its possibility for defining why we have business. So we suggest a redefined overarching purpose, which doesn't mean that we suggest to make all businesses the same. Rather, we suggest that the specific purpose of the business and the specific purpose of the business law in each situation should be positioned within an overarching purpose of sustainable value creation within planetary boundaries. And to make sure that that isn't just a possibility for more greenwashing, we also suggest redefined duties for the board of the undertaking. And we suggest there that when the board does its ordinary duties according to the business law that regulates that type of entity, that it works to, for example, then promote the interests of the company in a way that integrates sustainable value creation within a global goal of staying within planetary boundaries into its business models and strategies. And a key tool here is sustainability due diligence. So not human rights due diligence, not environmental due diligence, but more than that, sustainability in the broad sense that we define it. Due diligence across the business of the undertaking, which more often than not means global value chains. Nordic businesses are also global businesses. They're all connected. That each entity undertakes a sustainability due diligence to identify where its impacts are, and major risks for unsustainable impacts, and based on that, put together an ambitious plan for a continuous improvement process. That would give a basis for sustainability reporting that is actually relevant and reliable, which is not what we have today. And to make sure that this actually gives business, provides a level playing field for business that want to be sustainable, we also suggest that the process with the sustainability due diligence and identifying the impacts, that should be assured by external experts, and that sustainability reporting based on that should be audited, because it's time that we take people and the environment as seriously as we've been taking financial issues for decades or centuries. And also to make sure that this really gives the possibility for taking the competitive advantage away from unsustainable business and giving it to the businesses that are transitioning towards a sustainable future. We suggest that an array of public and private enforcement mechanisms need to be put into place. I'll share with you here a couple of references for further reading, including the chapter from the Cambridge Handbook that I mentioned, and I look forward to the discussion. Thank you very much.
Thank you very much,